Basically introduction to our TCA team, then introduction to Rahul and Rebecca, and opening remarks by Rahul regarding the current situation with COVID and related to immigration and any other issues. Then we'll jump into live Q&A with Rahul and Rebecca. This will actually our major time consuming. If you want to ask a question, use the chat option. You can just type in your question. I'll pick up, or Rahul or Rebecca can actually pick up from chat directly and start answering. Even if you do to everyone, or if something private, you can do me privately. You can see me. My name is Venkatuma, so you can do that too. Majority time we'll spend on answering your questions. And finally, we have a TCA helpline and other stuff, and we adjourn the meeting. So I'll jump into introduction. This is our TCA 2020 committee. Most of our members are here. Myself, Venkat Mumma, I'm a board of director. I have other two board of directors also in this call, Sivan Amala and Ram H. Manareddy. And our president is Brahma, is also in the call, and also general secretary, treasurer, and all other executive members also joined. Thank you so much for the committee members for taking this option. Also, I want to thank you, our lovely TCA sponsors for 2020. They are from real estate to healthcare professionals, hotels, everyone. Thanks one more time to sponsors. Now, going back to original topic, our attorney Rahul presenting this, and also is associate Rebecca Chenna also in this call. Rahul, if you can introduce your firm, about yourself, and also what you guys doing, and also about Rebecca, it will be great.
Hi, this is Rahul Reddy. I'm a founder of Reddy Newman PC. Along with me is my business partner, Rebecca Chen. Reddy Newman PC has been in business from 1997. So we have seen 2 recessions in our office. In fact, Rebecca, well, she has only seen 1 recession. She graduated, she was working before the recession. She was with us through the recession in 2008 and 2009. As soon as the recession over, she was the victim of it. We had to wait for some time to give her a full-time job as a lawyer. So she has gone through some of the things. So we're going to discuss mostly in about 2 to 3 minutes or 4 to 5 minutes on what we're going to present it. We would like more question and answer thing is what we prefer more. Rebecca, can you update, in 2 to 3 minutes, what is going on because of the COVID? What are the questions you're receiving of the people? What should they be concerned about? And, is there any leniency given by the government right now because of the COVID situation?
Right, unfortunately not. USCIS has been extremely unhelpful in the current situation as far as giving guidance or relaxing any sort of regulations or rules involving non-immigrant status. So since mid-March, the American Immigration Lawyers Association has been petitioning USCIS to basically grant grace periods for expiring I-94s or grace periods for continued work authorization for the duration of this national emergency that we are in right now. USCIS has not responded really to any of those calls for grace periods or moratoriums on departure requirements or I-94 expiration dates or work authorization expiration dates. The federal government has been extremely unhelpful, and it hasn't been helped by some recent media reports, especially in the past week or so, that have misinterpreted actually a couple of announcements by USCIS. As it stands right now, there are no changes from USCIS concerning I-94 expiration dates, work authorization expiration dates, or even requirements for departing the US when you have an I-94 expiring. Even though obviously the international travel situation is almost impossible right now. What USCIS did announce sometime in the past week was that they basically reiterated what the existing rules were for individuals in non-immigrant status who were dealing with these issues involving not being able to depart the US when they're required to. All USCIS stated in that announcement was that your options are to file for an extension or a change of status, which has always been the case before your I-94 expires. There has been some kind of misinformation around a possible 60-day grace period. There isn't really a 60-day grace period. What USCIS said in that statement is that if an extension or a change of status application cannot be filed timely, which means cannot be filed with USCIS before the I-94 expiration date, that they will take into consideration some of the extraordinary circumstances. However, that also is not really a new provision. That is basically what we've used for many years whenever there's been a missed filing deadline, the nunc-pro-tunc argument, where you can try to ask USCIS to excuse a late filing, but it's still in their discretion. It's not guaranteed by any means. Hopefully they will take into consideration any late filings given the situation right now, but so this has not been very helpful.
I want to also explain some people that there are people who are receiving COVID checks right now. If you are in H1 and if you're supposed both have social security number and you have filed a joint income tax returns, if you're receiving a check, take it, you can use that money, right? If you are a single person and you are in H1B, you filed you filed income tax returns, you are supposed to receive a check. If you don't, you need to contact IRS. Maybe they are very busy right now, but you should be supposed to receive the check unless you fall beyond the income level what they have described in. If you filed income tax returns on student visa only, student visa people file on it's called non-resident, so you may not be receiving the COVID check. If you are, if the couple, one person is on with a social security number like H1B, and the second person is an H4 TIN number, we have noticed that people are not receiving the check. It's because the spouse has the TIN number, you're not receiving the check. If anybody does receive it, please let us know, because if one couple is on social security number, another person is not. We have, as of now, we have been reported that they are not receiving, but if they are receiving, please let us know. People have asked the question with regards to, is furlough allowed? As Rebecca was pointing out, no new leniency was given to us right now. So furlough, technically, you have to count the 60-day grace period if they have furloughed you right now. Furlough, as you know, maybe that no work, no pay. The second one, can they cut the hours? Can they cut the salary? Depending on the circumstances, under limited circumstances, they could, but they have to file an amended H-1B application to do that. You cannot just furlough or cut the hours. So that may be considered not legal for the employers. People have asked me questions, can H-1Bs apply for unemployment benefits? Unfortunately, no, you cannot apply for unemployment benefits. However, the good thing about the H-4 EADs and L-2 EADs, they can apply for the unemployment benefits. Luckily, and right now, the unemployment benefits are, I think, it's about $600 plus a week. So practically about $1,000 a week. I may be wrong in that, but if H-4 EADs get laid off, it's perfect time for you. Can the OPTs, CPTs, and STEM extensions, can they apply for the unemployment benefit? The answer is clearly no. You cannot. Student visa people cannot apply for unemployment benefits. Any other things I missed out?
I would say for we've gotten a lot of questions for relatives who are here on a visitor visa. Even if it's not a relative on a visitor visa, if your H-1B or any non-immigrant visa is expiring, and if you intended to depart, but obviously are not able to right now because there are no flights, the solution in that case would be to file a B2 change of status or extension of status application. That's the form I-539 application. It can be filed online, and if you need guidance, you can contact an attorney, but it's a pretty straightforward application. It doesn't require a lot of supporting documents. It's better to file that application, even though the processing time for I-539s is several months right now. It may be longer than the 6-month period of extension that you're asking for, but still apply for the I-539 before the I-94 expiration date. Just go ahead and do it, because technically right now there is no guaranteed grace period, like we said, for missing the I-94 expiration date. It looks like we have a question in the chat. Is it okay if I just go ahead and start reading some of these?
I have actually one gentleman send me privately. I would start with that, then you can go with the second. Question is, I was working for a company A as my employer until January 6, and they revoked my approved H1. Same employer filed petition in February 14, and DHS came up and said that shouldn't work until approval of the petition in April 1st week. Now I have different employer who sent the petition. What is my current situation? I'm out of status but can legally stay in USA. I have spouse who is 140 approved. Is it better to change to H4 because of COVID? I am unable to travel. What we do now?
When did the I-94 expired for this person? You're saying that in January they withdrew the application, or it got denied, the extension got denied?
Yeah, I'm waiting for. Actually, I can open your voice if you want to ask direct question to the attorneys. I can do that too.
That's going to be better than good.
Yeah, let me unmute. Vijay, go ahead and speak.
Yeah, hi. Are you able to hear me? So yeah.
Yes, Vijay, we can.
My employer actually withdrew my petition on January 6th, and he reapplied with a new petition on February 14th, and I started working from February 18th with the new client. And
when is your I-94 expiring for you?
it is good until June 10th.
Rebecca, don't you see that he comes under the 60 days? Why is the officer will come and tell that you cannot work?
So the petition that was withdrawn in January, was it an extension application?
No, it was the first petition, and it is not an extension. It's the first. She got. I mean, I got it in 2019, and it is the first time.
So it was the one selected in the lottery.
Yes, right.
And it was.
I got it until for more than 1 year.
The officers who are coming to inspect, they don't have the legal authority to give legal opinion. They are supposed to just collect the information, report it back to the immigration bureau. So they're not supposed to give you. They're not supposed to give you a legal opinion whether or not you can be employed. Actually, in Texas and most of the states, for the people who are not lawyers, giving legal advice might be even crime. So I want you to contact your lawyer to make sure why is this officer telling the things. Maybe he should be referred to, if it's in Texas, maybe he should be referred to Texas Unauthorized Practice of Law Commission.
No, basically, just a second. Basically, when they ran the I-9 from the employer side, DHS gave a notice that this particular candidate should not be working until he gets an approval.
That's okay. So that's not the FDNS person, but that's the ICE, the one they're operating the. Okay.
Right.
Do you see a reason why they would say that, Rebecca?
I am not really sure why. So you've been working with this company on OPT using your EAD card?
No, I'm working on H1B with this.
No, before that, before the H1B.
Your H1B has not been approved, right? It was filed in April
no.
first time, and it was pending in January when it was withdrawn.
It was
It's approved. It's approved until 2021
Okay.
or so. So they withdrew it, and then he applied again. So we don't see a reason why. I don't see a reason why you cannot be employed. Vijay, you can drop an email to me. I will address that a little bit more to you on that. Okay?
Yeah.
Venkat will give you my email address.
Yeah. Okay. Sure.
All right. The next question we have on the chat. Is there a stimulus package for F1? My friend on F1 got the credit. What should he do? So basically saying somebody on F1 received the stimulus check. Is it legal? Or I think Rahul kind of understood.
We discussed, Rebecca and I discussed on it. They shouldn't be receiving it. I don't know why they received it. We request that this person contact a CPA and it makes sure that, CPAs are designed, when they get the money, take the money. Okay, that's how CPAs are designed. No, don't take that until, I would request the CPA to contact the IRS. How did you receive it? So that's very important, because on the F1 visa, you're filing, you don't pay Social Security, you file it as a non-resident person though. Maybe there is a mistake in the way the income tax was been filed. That could be the reason why you received the check. Rebecca, can you address on there is a 60-day grace period if you lose the job or so. Now, there is a rumor that the 60-day has been extended to 240 days. Is that true?
No, that's not correct. So the 60-day grace period that has been in existence since 2017 for H-1B visa holders, L-1 visa holders, most employment-based work visas. Basically, if you are terminated by your employer, but if your I-94 is still valid, you have 60 days from the termination date during which you can change to another status, file an application with another employer, like an H-1B transfer, or depart the US. So during those 60 days, for example, an H-1B transfer would not be considered late if it's filed within those 60 days. So that is a 60-day grace period that's always been there since 2017, basically. Yeah, there's been a lot of misinformation about it being that 60-day grace period being extended. It has not. The 240-day rule, which is also not a new rule, the 240-day rule, which has been in existence for a while, refers to H-1B and other work visa holders. Basically, if you are filing an extension application with the same petitioner and the application is still pending when your I-94 expires, you are authorized to continue working for that same employer for up to 240 days, about 8 months, beyond the I-94 end date, while that extension application remains pending. So that's the 240-day rule. It's not new. It just allows someone who has, for example, an H-1B extension pending to continue working beyond their I-94 expiration date for up to 8 months after their I-94 end date, while the extension application remains pending, which unfortunately right now is a very possible situation since premium processing has been suspended. And when that has happened in the past, regular processing times for H-1B applications have sometimes been a year or more. So that 240 days is going to be very important right now for anyone with a pending work visa extension application, but it is not an extension of a grace period. it needs to be based on a timely filed extension of status petition filed by the employer.
The question came from PP is that is the extension plus amendment, is it 240-day rule is applicable? The answer is no. 240-day rule is not applicable if it's an amendment plus extension. So even if your I-94 expires, if it's an amendment plus extension, you can work for the organization until the H-1B has been decided. So you're not obliged by the 240-day rule. One question that pops up very frequently, and also PP was asking, is that if the person have their job taken off right now, or if their extension is, if their H-1B is expiring, and they don't have anybody else, no job for them to file the extension, what should they do, and can they change back? Now, Rebecca already addressed that. If you're going out of status, please file the B2. You can file it online. It's called I-539. You can file it online. But do not expect yourself to move from H1, F1, or any other visa to B2 and convert back into H-1B. The main reason what we are noticing is that B2 takes a long time for you to get it adjudicated. So it may take 8 months, 10 months, even longer time. And normally B2 can only be applied up to 6 months. So you'll apply 6 months, you have to apply one more. It's not practical to change to H1 visa. So the only thing B2 is doing is allowing you to stay in the country until the flights and medical other things are being, safely there and move. Don't expect to move back to H1B. We have seen that, recession kind of thing, it may stay for a long period of time. Be prepared for it and just apply for B2. Anybody has any questions, guys, you can raise the hand. There is a column called raising the hands, or you can unmute yourself to ask the questions.
Yeah, I have a few. Wait, one. I'll read real quick. Can H4 EAD candidates who are currently out of job can apply for unemployment benefits?
Yes, they can.
Next question. Parents are in India on
One more. H4 EAD persons, sorry. Not
right.
just H4 persons, H4 EAD.
Correct.
And their work authorization should be valid.
Right. Parents are in India on green card in their 12 months or soon to be expired. Is there any extension from they can file with current travel restrictions?
What they could do is they could approach the consulate. The consulate will issue a letter for them to travel after the 12 months has expired. We have seen in situations where people, green cards expire or re-entry permit at certain times the things expire. They're not allowed to come into the country, but under extreme circumstances, especially medical circumstances, where people could not come within the 12 months, we requested the consulate and consulate routinely approved it, especially in medical conditions. Right now, it's not a medical condition. The condition, of course, is the COVID. Might come under medical condition if you feel so. But I think so they should be able to get that letter from the consulate so that they don't have any problem. However, Venkat, I want this person to be very careful, because if they have not traveled into United States for a 10-month period, okay, what was the history of these people? Do they have a bank account? Were they filing the income tax returns? Because it's absolutely necessary for the green card holders to file the income tax return. Are they maintaining the residence in the United States? So if you just go and say, well, every year I go for 2 weeks and I come back, okay, this time I couldn't go for this 2 weeks because of the COVID situation, the consulate is not going to give them the letter.
Right. All right. Thank you, Rahul. The next question.
Vamshi has this question. He's saying he used the word furlough. is there a rule that the salary is limited? Are there any salary restrictions for the H-1B? Once you on H-1B, you are supposed to receive a minimum of what it is stated in the LCA. If it is not, then you are in trouble, Vamsi.
All right. Next question. My I-94 expired on June 2019 and 240 days over on March 19th. Extension got denied on March 18th. As per my company, I applied for B2 on April month. There is around 3 weeks gap between extension denied and B2 application. Will be an impact in this situation.
Rebecca?
Yeah, possibly. I mean, even if it had been filed prior to March 18th or the denial date, it still was past the I-94 end date. Of course, I mean, it sounds like when the I-94 expired, we had no idea that the COVID-19 situation would be an issue. So it is going to be considered late filed. However, it is better than nothing to have an I-539 filed, just to show that, you know, basically filing a B2 right now, if you are having to stay here as a result of an H-1B denial, I would say it's more a statement or a gesture to the government that, you know, in the absence of the COVID-19 situation, you would have departed the US at this point, but are unable to because of the situation.
Rebecca, what would be the consequences? His H-1B got denied, let's say March 20th. Mm-hmm. How many days he accumulated the unlawful presence? And does it, yeah. And I also want you to explain if the unlawful presence, if the unlawful presence is less than 180 days, what are the consequences? If it's more than 180 days, what are the consequences? When did this guy's unlawful stay started counting?
Yeah, so there's a difference between being out of status and being unlawfully present. Those are two different legal concepts. You are considered out of status dating back to when your I-94 expired. Sorry, I don't remember when that was. I think it was sometime in 2019 that the I-94 expired. So as a result of the extension denial, you are unfortunately considered out of status for several months now, dating back to 2019 when your I-94 expired. However, even though you've been out of status for maybe like 6 or 7 months, you do not start accruing unlawful presence until March 20th or whenever the denial notice was issued, because until March 20th, you were technically, until you knew that extension was denied, you were in a period of authorized stay. You were able to stay in the US based on the pending extension. Once that extension was denied on March 20th, if you're still here, that's when your unlawful presence starts to accrue. So you haven't been unlawfully present for very long, about a month or so at this point. Unlawful presence, keeping an eye on how long you've been unlawfully present in the US. So keeping an eye on how long you're in the US after your H-1B denial is important, like Rahul said, because whether you have more or less than 180 days of unlawful presence makes a big difference in whether you are going to be allowed to come back to the US in the future. If you have more than 180 days of unlawful presence in the US, if you depart the US, then there's an automatic 3-year bar that applies to you before you can even try to re-enter the US. If you've been in the US for more than 365 days unlawfully present, the bar is 10 years. So you do have to keep an eye on, for example, 180 days from March 20th. Mark that date in your calendar, or from the date of the denial notice. Mark that date and keep an eye on it and make sure, if it's physically possible at all. I know a lot is uncertain right now with the travel situation, but try as best as you can to depart the US before that 180-day mark from the denial notice date.
We have a caller wants to ask a question. I'm opening his mic. Go ahead.
Oh, yeah. So, hi, my name is Rakesh. So my H1B is maxing out in June, actually. So I'm just wanted to know if I can't travel, what should I do? And my PERM is still in process, actually. So it's applied in Jan. So do you think the Department of Labor is still working?
Do you mean your 6-year limit is up in June? So even if your employer wanted to, they cannot get an extension for you beyond that?
Yes, that's right, Rebecca.
Okay. Yeah, unfortunately, there aren't that many options right now. The Department of Labor may still, it's going to be very tight because unless the labor is certified in the next month or so, even then there's no premium processing right now for the I-140. Usually in this situation, we would have you depart the US or change status before your H-1B expires. Since travel isn't really an option right now, we would recommend that you file an I-539 application. In our cases, usually we have people file a change of status to F1 to wait until the PERM and the I-140 can be approved and you can file another H-1B. If you do change status to F1, make sure you get the I-539 filed before June, before your I-94 expires. And if you change over to F1, make sure you're attending school to maintain your F1 status. We strongly recommend not using day one CPT as a way to continue your work authorization.
The question, what she was asking, also I want to address that. Labor Department is working full swing. We don't see any delays in the Labor Department at this point of time. In fact, most of the Labor Department people work from home anyway, and now they can't even go to movies, they can't go to sports events, they're working more longer. So we don't see anything in there. When it comes to the I-140, definitely there is no premium processing. So I would rather want you to plan to leave the country. Do you have an option for a H4, sir? You have an option to move to H4? Caller. If you have an option to move the H4, that would be best. Then the B2, F1, I would recommend that you contact a lawyer if you plan to. That's a very long run for you if you want to stay in this country. So B2 will be an option for temporary. H4, definitely, if you have that option, you should go for it.
Okay, thank you. So I don't have any other status. My wife is on H4, so.
Okay.
So do you think the premium processing will come back in June or July?
That's a very hard guess at this time. We have to be very experts in, looks like something else which we are not experienced in, called medicine.
Oh, okay.
Thank you.
Yeah.
Next question. I-94 expired, extension plus amendment. In this progress, there is no 240 rule for extension plus amendment. If yes, so need to change to B1 after 240 days, kind of statement and question.
Why? There is no 240 days at all for you, right?
It is actually in the chart for everyone. So I-94 expired, extension plus amendment.
If it's extension plus amendment, there's no 240-day rule for him.
Okay, all right. Next question. I have I-94 validity on I-797 till 2022, but if my employer plans to lay me off, I'll be getting the 60-day grace period. I do not have stamping and passport.
Yes, you will receive the 60-day grace period from your termination date. It's fine if you don't have a valid visa stamp. That's not relevant or required at all for the grace period. The visa stamp is only required when you are outside the country coming into the US to apply for admission. So as long as you stay here in the US, yeah, you'll definitely get the 60-day grace period. Hopefully you'll be able to find another employer, hopefully who can file your transfer during that time.
Okay. Question from Vamsi. For furlough, there is a rule that salary should not come below specific salary limit of position. Is that depends on DOL salary or my LCA petition?
So it looks like there are a couple of, for a furlough, we think of a furlough as basically being put on hold. You're not working and you're not receiving any pay. So if you're not receiving any pay and you're not working, then that is definitely a violation of H-1B status. Unfortunately, once you're furloughed, you are not maintaining status at all. If what your employer is proposing is reduced hours or a reduced salary, it looks like the question is, does the salary have to stay above what was listed on the petition or what was listed as the prevailing wage? So technically it does need to be what was listed on the petition. If the prevailing wage when your application was filed was $70,000, but your employer was paying you $80,000, they cannot go below $80,000 without filing an amendment, unfortunately. Even if the lower salary they're proposing would still be above the prevailing wage, they're bound by the salary amount that was listed on the I-129 form. And if they're going to go below that, they need to file an amendment petition first.
Okay, thank you.
The question that came on the chat is, H-1Bs are receiving the stimulus paycheck. They were being told not to encash because it's going to impact the green card. No, zip, it does not. According to the public charge rule, this particular check that is coming is not included in this in the public charge rule at all. So please, if you're on H-1B, you got the stimulus paycheck. They're actually returning the income tax that you paid. They're not giving you any more free money. That's the income tax you already paid. So you absolutely take it, cash it, use it, whatever you want to do it, save it, whatever, I'm not a financial advisor, but it won't impact your GC. His second question was that, is there a chance that if the beneficiary is not picked up in the initial registration, what are the chances for them to get it picked right now, Rebecca, if they're not picked up in the lottery?
Yeah, it is hard to say. I would say in a normal year, it is very rare or very unlikely that USCIS would do another round of selections after their initial lottery selections in April. This is a more unusual year because of both the way the lottery was done this year, the timeline, plus this economic downturn that has basically happened at the same time. It is possible that we'll see, we have until June 30th for the selected applicants to have the H-1B petition filed for them by their employer. It does seem like a possibility that a number of selected applicants may not have that application filed for them by June 30th because of layoffs and the economic downturn. Whether that number of people who don't end up submitting an application is significant enough for USCIS to do another round of selections, it's really hard to say. I think it will depend on, there may be a number of employers right now who have selected people and they're just waiting until closer to June to determine if their financial situation allows them to file that H-1B petition. In every year, USCIS typically selects more than the 85,000 that they're required to select, because they already presume that a number of them will be withdrawn, denied, or revoked. So USCIS has already selected more than they need. I think it would take a pretty significant situation where a lot of employers are not filing for their selected people by June 30th in order for them to do another round of selections. But it is possible. This is a very unusual year, of course.
I have a private question from Ms. Vandana. if a student starts studies for MS in H4 visa and has applied for F1 visa, will he get OPT if F1 visa approves?
Yes. There is no requirement that the person has to be 1 year on F1 visa. Luckily, they're not interpreting that way. So if by completion, before completion, she gets the F1 visa, she would be eligible for getting the OPT. Obviously, she has completed more than 1 year coursework has to be done to get the OPT, which includes the period of H4 and also includes the period of F1. Rebecca, you want to add or correct?
Yeah, that's correct.
All right. I have one private question in the chat. I have requested STEM OPT from August 2019 to August 2021. However, the actual dates on the EAD that I received is from July 2019 to July 2021. Should I request USCIS for correcting my EAD work authorization dates? If yes, is it too late to do it now?
July 2019 or July 2020? Or is it if it's only 1 month, would you dare to go and submit it back to them, employment authorization document, and request a correction, Rebecca? Or just keep quiet, don't do anything?
If it's just 1 month, I probably wouldn't do it because it does require you to mail back your current EAD, and if you need it for work authorization,
and then
license.
Yeah, and they may correct it, they may not correct it, but you have to send your original approval to them. And I would not risk that for a 1 month period.
Yeah, that is for others. The next one, okay, Rahul. L2 can be extended in USA. I think your statement. One more.
What is the deadline to file the H1B new lottery system, Rebecca, if it's been selected in the lottery?
So the H-1B petition must be filed with USCIS by June 30th for people who have been selected in the lottery.
Is there any exception because of the COVID situation?
Oh, not because of the COVID situation. As of now, it's still a hard June 30th deadline. There are exceptions for individuals who, if your EAD expires before June 30th, and you are going to be relying on the cap gap to continue your work authorization over the summer. In that case, your H-1B petition needs to be filed before June 30th. It needs to be filed before your EAD expiration date in order for you to be eligible for the cap gap.
So Rebecca, after June 30th, nothing can be filed. And some of the people are forced to file. The June 30th is not the deadline for everybody, but for the OPT and STEM extension, which is expiring before June 30th, they have to go with the OPT and STEM extension date, right?
Right.
Yeah, so far I'm still waiting for questions. Rahul sir, I have my own opposite way. So Indian government canceled all visas, OCA cards, everything for US citizens. I know technically they can do. If you want to go, what should we do? Like an emergency?
They suspended it. They didn't cancel it.
Yeah,
suspended it.
Right.
Yeah, I am not, though I have a law license in India, I'm not that good expert in it. Right now, every country is trying to save their own citizens rather than actually helping other citizens up. Now, overseas citizen of India is technically is a visa, though. It's not a citizen. You're not an overseas citizen. According to the Constitution of India, there is nothing called overseas citizen of India. It's just a act through which the government passed, and most probably by the executive order. I don't know, but it's not passed. It's not in the Constitution. You don't have much rights, though.
Okay, so we just wait to revoke the suspension?
Right.
Okay.
You have to wait for the revocation of suspension.
All right. You have open question? Okay, so he wants to.
Nag,
Yeah, I'll open his mic. Nag. Give us. Where is Nag?
you can raise the hands on the Zoom application. Too,
Yeah,
guys.
that will be it. Yeah. Nag, can you raise your hand? I'm not able to. I got it.
Yeah, I see one other Subramaniam Swami raising the hand.
Yeah, Nag is online. Yeah, Nag, go ahead.
Hi, I'm a US citizen and I've actually started green card processing for my mother. And it's in the process. I think now all the fingerprints, everything has gone through. And they were actually, just before all this happened, before USA was closed down, we got an update saying that she has to attend a 485 interview. But now everything is in lockdown. Her I-94 actually expired by March 6th. So I'm just wondering, is she safe to continue staying here, or are there any concerns here?
Absolutely. If the person I-94 is expired though, it has no meaning. I'm assuming that you already filed 485 and I-130 application.
Exactly.
So once you file that application, it doesn't matter whether the B2 I-94 expire. It won't matter at all. As far as the interview is concerned though, yes, it is delayed right now. They will reopen it, of course, some point of time, and they will call her back for the interview, and then you go for the interview. But as far as her staying in United States, absolutely no problem. Do you need to file a B2 extension? No, you don't need to file B2 extension.
Okay, that's good. Okay, thanks for the information. So just wondering, one more question. What to expect for an I-485 interview? I've never came across such a situation, so I'm just checking.
One thing I'm concerned about is that after your mother entered into United States, how long after you file for the B2?
B2?
I'm sorry.
130.
After she entered into United States.
Okay.
How long after you file for the green card though?
Yeah, she entered in September, first week. I filed in end of December, middle of December.
September, October, November. No, yeah, okay. Yeah, practically, I don't, Rebecca, he looks clean on the 90 days. I was a bit worried.
Yeah.
That's good. That's good you got for the interview so quick. I'm not worried much at all for any interview thing.
Okay.
Sometimes though, Nag, I'm from India. I'm also a licensed lawyer in India.
Mm-hmm.
Sometimes they are very picky on the documents. And you know, Nag, some of the documents, your mother might not have a birth certificate. Maybe you don't have a proper birth certificate.
Exactly.
Those are the things, but I will give you a weapon. You can carry it with you,
Mm-hmm.
and you can use it, and it works so good. Okay? I will tell you that secret weapon to you. Okay?
Okay.
It's called DNA.
DNA. Okay.
Just use the word DNA. They'll be flat. They'll approve it. If by any chance you get into those documents, hey, this document is proper, that document is not proper, offer the officer that you're willing to get the DNA test. They may just flatly approve it, or at the most they'll say, okay, get the DNA test and I will approve it.
Wonderful. Yeah, that's real something to carry in my pocket. Yeah.
Yeah, you can carry it.
Yeah. The next one,
one last question. Can I just finish up one thing? So my mother is not so good in English. I've actually completed an application as a translator, so I can still join her when she's going to the interview, right? Okay.
Absolutely.
Okay.
It may be defensive if you take your wife as a translator. Some of the officers have sometimes problem, but typically for mothers though, they don't. That's the least fraud thing according to them though. So I would recommend to take one other person other than yourself. Even your wife would be fine too.
Yeah. Thanks, Rahul. Next question, Subrameshwara Swami. You can speak now.
Hi, thanks for this opportunity. So I have a question regarding filing the petition of the new lottery system by June 20th. So what if
June 30th.
Can you hear me?
June 30th.
Yeah,
Yeah, Subramanian Swamy, it's June 30th.
Yeah, about that, what if there is a chance that we do not get all the documentation necessary by that? For example, I am a dentist, and then I'll be needing my professional dental licensure for the state dental board. So every state dental board works differently, and it may take at least 2 to 3 months to get my licensure from now, even if I apply today. So my question is, what happens if I don't get the document by June?
Rebecca, is it sufficient enough for him to certify saying that he completed all the requirements? He's just waiting for the state to give it. Would you file the application?
Yeah,
with that?
I will definitely file it no matter what before June 30th.
And we can
no
wait for
point in, yeah, and just wait
no matter
for evidence.
No matter what, you're going to file it, and you will face the immigration afterwards, right, Rebecca?
Yeah, most likely they'll just send a request for evidence in RFE.
All right, okay, that answers it. Thank you.
Subramanian Swamy, we normally have defense that you have completed all the paperwork required by April 1st, or whatever. I'm sorry, whatever time you file an application. And it's just they did not granted it. That might be a good difference, especially under the current circumstances.
Okay.
But under no circumstances, you finally got the lottery. Under no circumstances, I mean, you have to file this application, period, before June 30th.
I get that. I'll get my degree and all that's required document except for the licensure. So maybe I think I'll be good to go and file by June 30th. Thank you.
All right. We have one question in the chat. Is there a way to apply for H-1B extension for 1 year when the 6-year limit reaches in August of 2020? And with perm in process and if approved by July 2019, an I-140 filed and receipt notice received. He actually corrected, it is not July 2019, it is
July 2020. So Rebecca, the question here is, the perm was filed, let's assume the perm was filed in January of 2020. If the I-140 is pending, is he eligible to file the H-1B extension beyond 6 years?
Unfortunately not. If the 6-year limit is going to be reached in August of this year, then an I-140 receipt notice is not going to be enough, unfortunately. The rule for obtaining a 1-year H-1B extension in that situation is if the perm was filed before you started your 5th year, or sorry, before you started your 6th year of H-1B. So it would have
which should have been August
2019.
August 2019, yeah. There are situations where we file the extensions. However, those situations are that actually you have the H-1B only until August 2020, but if you're eligible for the next 3 months because of the under 6-year limit though. So let's say, for example, instead of your 6-year limit is expiring in January of 2021. Your H-1B is expiring in August of 2020. Since your perm was being filed in January 2019, we do commonly request beyond 6 years. But in your case, since your H-1B is expiring in August and that is the 6-year period, you are in a very, you can't do it though. You want to consider maybe looking into other options. Maybe take a leave of absence, maybe go to India for a while so that your I-140 gets approved, or maybe convert into other visa status. You might want to consider all those options. If anybody else has any question, please raise hand in the Zoom application, guys. We will be able to see you.
Yeah. Before it comes, I have one for you. If you sponsor a sibling for family-based green card, the same sibling can go for a visitor's visa at the same time, or it will be an issues?
Most likely not. Yeah, once the I-130 is filed, it's going to be very unlikely that a sibling will be able to get a B2 visa from a consulate.
I would still recommend, if they want to apply, they can. But one thing they have to be very sure is that in the DS-160 application, has an immigrant visa petition has been filed, they need to answer that question yes. If they answer no, that's a misrepresentation. They can never come back into the United States. If they answer yes to that question, I would recommend the sibling to be speaking with a lawyer more thoroughly, because we have had situations where people have I-140 approval, they still come under B2 visa. I would recommend that they speak with a lawyer and be prepared with the questions. They have to answer this question. Do you want to immigrate to the United States? I mean, they have to say yes, because there is an I-130 application. Right. What they need to prove to the consular officer, I do have an intention to settle in United States. I have no doubt I want to do it. But the trip that I am making right now, let's say, for example, if they're making a trip for the nephew's graduation or so, I just want to go for the nephew's graduation and I'm going to be coming back. I do have an intention, but this trip is temporary. We have seen some successes in this one, but they just need to be prepared. They can't dodge the question. They should not answer, I have no intention to immigrate to the United States. Then they should have withdrawn the I-130. Why is the I-130 still pending there? So they need to be very frank in answering the question. Yes, I want to immigrate to the United States. That will make the officer much better.
Okay, so you're suggesting better apply visitor's visa before filing an immigration petition, if they want to visit you?
Well, that's a different question though. If they want to immigrate to the United States, I mean, if somebody wants to file an I-130 application, I will put a hold on it until they get the B2 visa. But Venkat, there is also another issue that what Rebecca is also very concerned about is that even though the B2 was being issued before, the I-130 was being filed afterwards. Every time the person comes into the United States, they have to prove their intention is only to temporarily come into the United States. What I spoke with you with the consular officer, they should always be prepared at the time when they're coming for the CBP officer too.
Right, at the airport. Got it. Makes sense. Yeah, we have one more question in the chat. Asking for one of the scenario H1 to B1, and once H1 approved, can B1 to be H1 be done without leaving country?
No, that's going to be very unlikely that you'll be able to change back from B1 or B2 to H1 without having to leave the country. So yeah, because of the difficulty of departing the US right now, we are recommending that people in some situations file from H1 to a B visa, file that application. But for a number of reasons, because it's going to be a very long time that I-539 application is going to be pending, in combination with the fact that it's very rare anyway for a B to H1B application to be successful. Most likely, in order to get back into H1B status after filing the B change of status, it's most likely going to require filing a new application and going through consular processing at a later date, hopefully when the consulates have reopened.
It's practical. The legal answer to the question may be that the person could change without leaving, but the way the USCIS is operating the B1, B2 visa, I mean, it's taking long for them to adjudicate. It's practically impossible to get the H1B visa.
Whoa.
You want to open some more tape?
Yeah, I have a couple of questions. One before it passes. From Aditya, Indian passport is expiring in November 2020. By when it will be possible in current scenario to apply for passport renewal in USA? I am on H1.
I need to know when his H1B is expiring. The rule for the H1B is that when you're applying for an extension, your passport has to be valid. It doesn't have to be the validity, doesn't have to be all the way you're requesting the H1B. So if his H1B is expired, if he's filing an H1B in August of 2020, he can apply in August of 2020. It doesn't matter that his passport is expiring in November 2020. He could still get a H1B extension for a 3-year period. That's number one. Number two, we have noticed that the Indian consulate is working 24 hours. In fact, I just received a notification saying that there is a helpline available for the people. They are extending the passports right now, especially under your situation right now.
Yeah, he said it's valid till December 2021.
I'm sorry?
His
H1B is expiring.
Yeah, till December 2020.
Yeah.
So he got one year.
Oh, yeah, that's fine. Yeah, if your passport expires, you're not illegal in this country. If your I-94 is expiring in 2021, you're perfectly legal. Just your passport expires. Doesn't have any meaning at all on the non-immigrant visa. And duly in course, the Indian consulate will extend the passport. If there is a lapse in the passport, it won't affect your immigration status.
All right. Vijay, actually I unmuted you. Can you ask your long question? You have follow-up questions also, better to speak.
Yeah, sure. Actually, I have asked the question before also. Like, I have the approved H1B until May 31st, and my application was withdrawn in January, and the same employer again filed it in February 14th. And
right. Vijay, I request. It's going to take a little bit long. That looks to be very unusual. Why the eyes have said that you're not? If you would drop an email to me, I will call you back tomorrow.
Okay, sure. Thank you.
Yeah, we have one more speaker wants to talk. Samson, I want to know his name. Or raise your hand.
It is Samsung raise the hands. You need to, Venkat, you need to click on it.
Yeah, I got it.
Hey, thanks. Quick question. So if somebody is on a L1 visa and they're about to max out the 7-year period, but they get a approved I-140 and the file currency date, of course, we know there's a retrogression, so it's running a bit behind. Can they convert to a H1B can they convert to a H1BA by means of lottery selection, or will it be an automatic just by application because they have got an I-140 approved? How does this work?
Yeah, so
You don't have a H1. You don't have a H1B lottery until 2021 October. Rebecca, you're speaking something?
Oh, yeah, I was going to say, if you haven't had an H-1B visa at any time in the past, you are still subject to the lottery. Unfortunately, it doesn't, having an I-140 approval or being an L1 doesn't allow you to forego the lottery unless your employer is a CAP exempt organization, like a university or something like that. So, yeah, in these cases for L1s that have a 5-year or 7-year limit, those cannot be extended based on an approved I-140. And so we would usually have those L1 visa holders start applying in the H-1B lottery, hopefully a couple years before their limit, so that you have as many chances as possible to get selected in the H-1B lottery. But if you haven't already done that, then, and depending on when your 7-year limit is up, like Rahul was saying, the lottery for this year is already closed. Essentially, it won't be open again until next March. So that will be your next opportunity to submit yourself in the lottery, H-1B lottery.
Thank you, Rebecca. Is anyone wants to ask a question, or you can post in the chat. There are a lot of questions so far. All right, keep posting. We'll have a few more minutes. Okay, Rahul wants to ask a question. Yeah, Rahul, go ahead.
Yeah, actually my mother's B2 visa is going to be expired in the month of September 2020. So if I want to file the extension for her, so what are all the supporting documents is needed, and when he can file the extension?
Is it B2 I-94 is expiring or B2 visa is expiring?
B2 I-94 expiring on September 1st.
We do not recommend you file for her extension at all. Here is the reason why you do not. They are supposed to visit the kids in the United States. I understand, Rahul. You have a good first name, though. But the U.S. government people, they don't understand why moms visit. Not, they consider mom and daughter-in-law. Okay, they don't consider mom and son. How moms visit the daughter-in-laws and stay them for more than 6 months. So if you're extending the B2 visa, you're risking very much. Typically, your mom might have a 10-year multiple entry visa, right?
Yes, correct.
Yeah, any rejection of the B2 visa, and she stays 1 day undocumented in this country, unlawfully in this country, then her passport visa is automatically cancelled. That's one reason why you should not file B2 extension.
Okay.
Second reason why you should not file a B2 extension is that whenever she is coming back into the country, remember we are speaking about the person who applied for the green card application, they're trying to come on B2 visa. Every time your mom is coming into the country, it will be a doubt that why is this lady coming for a long period of time? Is she actually staying in the United States and visiting India? So that's the second reason why you should not file the B2 extension. The third reason why you should not file the B2 extension is that later on, when the 10-year multiple entry visa is over, if she wants to reapply for the B2 visa, you're good chance that if she extends the B2 visa, she'll get the rejection for that visa.
Okay. Okay, but right now the situation is different, right? So the situation is like,
if the situation remains like this, it may make sense for you to apply for the B2. There's no doubt if the situation is like this.
Okay.
But we maybe, I don't want to be an expert in the doctor, but maybe cleared up by September. But if not, under these extreme circumstances, it may be okay for you to file the B2.
Okay. Thank you, Rahul. Thank you very much.
Rahul, sir, we have one question from one of our executive member. Is it okay to claim unemployment benefits with H4 EAD, with a valid H4 EAD?
Rebecca?
Yes. So holders of EADs who are on H4 or L2 status are eligible to claim unemployment benefits. The reason that they are able to get unemployment benefits while H1B and L1 holders cannot is because unemployment benefits require you to have an unrestricted ability to accept employment. So an EAD is considered unrestricted ability to accept employment because you can go work for any company or any position, whereas an H1B or an L1 requires an employer to file a visa petition for you first before you can work for them. Having said that, H4 EAD holders can claim unemployment benefits, but only for the duration of their EAD validity. So if the EAD is valid until November of this year, if the new EAD card has not arrived by then, the EAD holder is not eligible for benefits for the months after that, for December, for example.
We published an article in rnlawgroup.com saying that the H4 EADs should apply, and we got a lot of setbacks from a lot of people saying that how can they do it? It's a public charge. They cannot get the green card. we put the link to the USCIS website, and in that link, it clearly says that unemployment benefits is not considered as a public charge.
All right. Now, one of our BOD, Venkat Namala, Rahul Garu, you know him.
Hi, Rahul.
Both you and Rebecca was here in 2017, if you remember. We did in a temple setup.
Sure.
Yeah.
During that time. Venkat Garu.
Hi, Rahul. Can you please address, is there any guidelines to handle the emergency travel situations to India or any other out of country?
Right now, India's borders are closed. If you want to, Bangladesh is open, Nepal is open, Sri Lanka is open, but I don't know how you're going to go from boat to India. But Bangladesh is open and Nepal is open too, to my understanding. I checked the airlines, Bangladesh is still open. So that's the only thing that I can.
How can we enter from Bangladesh or Nepal to India with US passport?
No clue.
So go by what? Like I think Nepal, they don't check, you don't need to have passport to enter.
Yeah, Nepal, you don't need any passport to enter to Nepal. But how are you going to come from Uttar Pradesh or Bihar all the way to wherever you want to? Recently, I will tell you one of the experience. One of the family that we know, they were being forced to have they were forced to have the isolation in Delhi for 14 days. And by the time that isolation, which they were staying in a hotel, expired, now there is no flights from Delhi to Hyderabad. So they took permission from the superintendent of police, and it is taking them 2.5 days to travel with 2 drivers in a minivan for them to travel. So even if you were being found to be legally allowed to enter into the country from Nepal or somewhere else, they'll put you in a quarantine for 2 weeks, maybe in Bihar, and then you will be allowed to travel on a police permit, and that they were telling us somewhere about 70 or 80,000 is the cost it's costing to drive from Delhi, because the drivers have to go back to.
Oh. Yeah, thank you, Rahul.
All right. Any more? We kind of reached the peak. Still, if we can ask 1 or 2 questions. Seems we don't have any. So if you see my screen, Rahul's there's so many options you can reach Rahul or one of their attorneys. So they have a daily conference call. It's a telephone conference call. You can see the phone number.
Yeah.
Monday to Friday, no Saturday, Sunday. But the time changes, 3:30, 11:30, and 4:30, that is. And one of the best, actually, I do sometimes attend is their Facebook Live. Every Tuesday at 5 o'clock. It will actually go for at least 1 to 2 hours sometimes. Many folks join. It's an interact section. You can ask questions the same way. Rahul will answer you. Also, you can reach their office. The phone numbers are there. Also, the email, website, rnlawgroup.com. Sorry, Rahul, you want to say something?
No. Thank you very much, Venkat. Thank you very much. Both Venkats. It's a very pleasure always to work with us.
Thank you. I'll speak in Telugu. Sorry, Rebecca.
No problem.
Without hesitation, you just come in a day's notice. Chal, thanks, Rahul bhai. Appreciate that. Also, I know you had so many students whenever they reach to you from Austin. So thanks again for your services, not only as an attorney, but as a community to the entire Telugu folks. Thanks again. I have one more last slide about TCA. We actually have a TCA helpline for the COVID-19. Can be related to anything. You're suffering with immigration, very serious issues, or health issues, anything, you can reach our helpline. We will try to address as much we can. Maybe you need a doctor assistance or some suggestion, anything. So please don't hesitate to call. It will be private and will not be disclosed anywhere. So feel free to reach anytime. You can also reach through our website, austintelugu.org, and contact. If you can post a question through, it will trigger an email to us. That also we can respond back. And also we are collecting small donations for COVID-19. We are donating groceries, small things to local temples, priests. Anything if you want to contribute, we have PayPal. You can see on the screen, paypal.me/TCA Austin. Just donate. It is only for COVID-19 purpose. And finally, if you can make a friend on Facebook, it is Telugu Austin. Just send a friend request, or we have a page, Telugu Cultural Association Austin. If you like, you will get all the feeds like these kind of programs, what we're going to do. It can be beneficial. We don't do any spam, guaranteed. On Facebook, we just publicize our upcoming events. That's it. Rahul, sir, conclusion? Anything?
No. Thank you very much. Thank you very much, Rebecca, for coming in.
Thank you for having us.
Thank you, Rebecca. Thank you, guys.